Lord Justice Scrutton, quote, "This appeal raises questions of great importance regarding the liberty of the subject, a matter on which English law is anxiously careful and which English judges are keen to uphold, as Lord Herschel says in Cox and Hakes, 15 App. CAS 506-527. The law of this country has been very jealous of any infringement of personal liberty. This care is not to be exercised less vigilantly because the subject whose liberty is in question may not be particularly meritorious. It is indeed one test of belief in principles if you apply them to cases with which you have no sympathy at all. You really believe in freedom of speech if you are willing to allow it to men whose opinions seem to you wrong and even dangerous, and the subject is entitled only to be deprived of his liberty by due process of law, although that due process, if taken, will probably send him to prison. A man undoubtedly guilty of murder must yet be released if due forms of law have not been followed in his conviction. It is quite possible, even probable, that the subject in this case is guilty of high treason. He is still entitled only to be deprived of his liberty by due process of law." Page 387. If, before the Irish Free State Constitution Act, a Secretary of State could order internment in Ireland, the continuance of this power is in consistence with the creation of an Irish executive in the same position as that of the Dominion of Canada, and having in consequence exclusive executive jurisdiction within its territory. Therefore no such order could be made by a Secretary of State after the passing of the Irish Free State Constitution Act, because the previous law allowing it was inconsistent with the provisions of the Irish Constitution so far as they created an Irish executive, and that previous law was therefore repealed. The power also ceased to exist because the regulations did not allow internment by order in a place where the person ordering had no control of the internment, and the creation of the Constitution had converted Ireland into such a place as regards the power of control of the Secretary of State. Page 391. There remains the question whether a writ of habeas corpus is the appropriate remedy for the illegality of the order in detention. Now, it has been laid down by the House of Lords in Bernardo and Ford, 1892, AC 326, that if the court is satisfied that the body whose production is asked is not in the custody, power, or control of the person to whom it is sought to address the writ, a writ of habeas corpus is not the proper remedy, though there was an original illegal taking and detention. The object of the writ is not to, page 393, punish previous illegality, but to release from present illegal detention. It may be that on hearing that, in the opinion of this court, the order was issued without legal authority, the Home Secretary, with the assistance of the Irish Free State Government, will produce the body, as it is hardly in the interests of either government to act illegally." End quote. Page 393, Lord Justice Atkin, quote, "The case involves questions of grave constitutional importance, upon which I feel bound to express my own opinion, even though I repeat to some extent the views already expressed by the other members of the court. That a British subject resident in England should be exposed to a summary arrest, transport to Ireland, and imprisonment there without any conviction or order of a court of justice is an occurrence which has to be justified by the minister responsible." Page 394. "Apart from the effect of the creation of the Irish Free State, it cannot, I think, be disputed that the powers of making regulations given by the Restoration of Order in Ireland Act 1920 included the power to make Reg 14b, R. and Halliday 1917 AC 260, nor can it be disputed in this court that the regulation empowers the Home Secretary to exercise in England the powers given under it, ex parte Brady 91 LJ KB 98. A decision, page 395, which binds me and therefore which I do not discuss. When I consider the effect upon this regulation of the Irish Free State Constitution Act 1922, I am forced to the conclusion that the executive powers given to the ministers named in the regulation and essential for the efficiency of any order for internment in Ireland no longer exist." Page 396. "I think, therefore, that Reg 14b, so far as it relates to a power to intern in the Irish Free State, is repealed by the Irish Free State Constitution Act. Having come to this conclusion on the broad constitutional point, I need not deal at much length with the other points raised, but even if there were otherwise power to order a person to be interned in Ireland, I am of the opinion that the absence of any power to modify the restrictions incident to internment would in itself be fatal to the validity of the order." Page 397. "Moreover, I think that the Home Secretary had no power to order the applicant to be interned in such place as the Irish Free State Government may determine. This seems to me to be the very contrary of a place specified. The choice of place obviously determines the conditions and restrictions under which the subject is confined, and in my opinion the Home Secretary had no more right to delegate the choice of place to the Irish Free State Government than to the first man he met in the street. I think that on this ground also the order is invalid." Page 398. "Having come to the definite conclusion that the order made by the Home Secretary is invalid and that the imprisonment of the applicant thereunder is unlawful, it only remains to consider whether the writ should go to the Home Secretary. I think that the question is whether there is evidence that the Home Secretary has the custody or control of the applicant. Actual physical custody is, page 399, obviously not essential. It seems to me that much support for the contention that the Home Secretary retains de facto control is afforded by the words of the order itself, a copy of which is served on the applicant. The order is that the applicant shall be interned in the Irish Free State and shall remain there until further orders. It was conceded that the ordinary interpretation of those words would be until further orders by the Home Secretary, though it was said that in fact he had no power to give such orders. I cannot without further explanation accept this. The order proceeds, if I am satisfied by the report of the committee that this order may be revoked or varied without injury to the restoration and maintenance of order in Ireland, I will revoke or vary this order by a further order in writing under my hand. Failing such revocation or variation, this order shall remain in force. I cannot explain these provisions on the footing that there is no de facto control. In this case it is plain that the applicant was at one time in the custody and control of the Home Secretary by an order which we have held to be illegal. There is, to say the least, grave doubt whether he is not still in the custody or control of the Home Secretary. The case of Bernardo and Ford appears to me to afford ample ground for the conclusion that this court should order the writ to go addressed to the Home Secretary in order that he may deal fully with the matter, and if he has in fact parted with control, show fully how that has come about. The rule must be made absolute." End quote. R versus Electricity Commissioners, LR 1924, 1 King's Bench 171. The Electricity (Supply) Act 1919, 9 and 10, George V, C100, Sections 5, 6, empowered the Electricity Commissioners to formulate schemes for the improvement of the existing organisation for the supply of electricity in electricity districts and, where necessary, for the formation of a joint electricity authority for a district, and directed them to hold local inquiries on the schemes. By Section 7, subsection 1, the Commissioners were empowered to make an order giving effect to the schemes embodying decisions arrived at as the result of the local inquiry, and present the order for confirmation by the Board of Trade, now the Minister of Transport, who might confirm the order with or without modification as they thought fit, and by Section 7, subsection 2, any such order shall be laid as soon as may be after it is confirmed before each House of Parliament, but shall not come into operation unless and until it has been approved either with or without modification by a resolution passed by each such House, and when so approved shall have effect as if enacted in this Act. The Commissioners formulated a scheme in purported exercise of their powers and were proceeding to hold a local inquiry with a view to making an order giving effect to the scheme. On an application for writs of prohibition and certiorari, it was held by the Court of Appeal that the scheme being ultra vires, a writ of prohibition should issue, prohibiting the Commissioners from proceeding with the further consideration of the scheme. Page 189, Lord Justice Banks. Quote, the important part of the appeal has reference to the jurisdiction of the court to make any order either for prohibition or certiorari. The first objection taken was that any application was premature, page 190, the matter being still only in its opening stage. The Commissioners, it was said, have decided nothing. They have merely published the scheme preparatory to holding their local inquiry thereon, which they are directed by Section 5, subsection 4 of the Act of 1919 to hold before making any order. This objection may be a valid objection to the granting of a writ of certiorari, but as it is not necessary to decide the point, I express no opinion upon it. With regard to prohibition, if the writ lies at all, I do not think that the objection is a sound one. The other objections to granting any writ were much more serious, and they raised difficult and important questions, constitutional as well as legal. In substance, the objections come to this: A, that the proceedings of the Electricity Commissioners are of an executive and not a judicial character. B, that whether that be so or not, their page 191, proceedings in reference to the preparation of schemes, as directed by the Electricity Act 1919, are controllable by Parliament and by Parliament alone, and are such that there is no moment of time at which the court can intervene to inquire whether the proceedings are ultra vires or not. The argument on this second contention is presented in the following way. Section 7 of the Act, it is said, provides that the Commissioners may make an order giving effect to a scheme, but that order has no force or effect in itself. It is merely a suggestion or advice to be passed on to the Minister of Transport, who may confirm or modify the scheme. Even then the order has no force. It must first be approved by resolution passed by each House of Parliament, and then, and not till then, has the order any force or effect. As soon as the order has been approved by both Houses of Parliament, the section provides that it shall have effect as if enacted in the Act. The result, according to the respondents, is that any application to the court for a writ of prohibition or certiorari must be either premature or too late. Premature if made before the order of the Commissioners becomes an Act of Parliament, too late if made after it has attained that status. This argument has only become possible since the legislature has adopted the practice of providing that resolutions or orders which are directed to lie on the table for a certain period before becoming effective, or which have to be approved by resolution of the Houses of Parliament, are, when approved, to have effect as if they were themselves Acts of Parliament. The effect of legislation in this form was discussed in the case of Institute of Patent Agents and Lockwood, 1894, AC 347-365, where Lord Watson concludes his speech by saying, "Such rules are to be as effectual as if they were part of the statute itself." The effect of accepting the argument of the Attorney General on this point would be very far-reaching. It would amount to a decision that the subject has no longer the right in cases like the present, where this form of legislation is adopted, to come to a court of law and demand an inquiry whether the action or decision of which he is, page 192, complaining, is ultra vires or not. I question very much whether Parliament had any deliberate intention of producing the result by adopting this particular form of legislation. I pass now to consider the contention that if the Court makes an order in the present case for the issue of a writ of prohibition, it will be trespassing on ground reserved by Parliament to itself. I cannot see why this action of the Court should be so regarded. By the Act of 1919, Parliament laid down the limits of the jurisdiction of the Electricity Commissioners. It did so presumably because it considered that those limits were the proper ones and the ones which the Commissioners should observe. Why should Parliament object to a court of law, if appealed to, using its powers to keep the Commissioners within those limits? Parliament no doubt has, as between itself and the Commissioners, provided that no order of the Commissioners shall have effect unless first approved by Parliament. This reservation must, I consider, be treated as a reservation for the purposes of control, and does not, in my opinion, exclude the jurisdiction of the courts of law. If any decision of a court of law in the opinion of Parliament unduly fetters the action of the Commissioners, it is always open to Parliament to extend the limits of that jurisdiction. I have so far only dealt in a general way with the arguments addressed to the Court by the Attorney General. The real question is whether the principles already down in reference to the power and duty of the courts to issue writs of prohibition apply to the present case. There can, of course, be no exact precedent, as the Electricity Commissioners are a body of quite recent creation. It has, however, always been the boast of our common law that it will, whenever possible and where necessary, apply existing principles to new sets of circumstances. Page 198. The conclusion I have come to, in reference to the whole matter, is that there is abundant precedent for the Court taking action at the present stage of the proceedings of the Electricity Commissioners, provided it is satisfied that the Commissioners are proceeding judicially in making their report, even though that report needs the confirmation of the Minister of Transport and of both Houses of Parliament before it becomes effective. In coming to a conclusion on this latter point, it is necessary to deal with the case on its own particular circumstances. The Electricity Act of 1919 imposes upon the Electricity Commissioners very wide and very responsible duties and power in reference to the approval or formulation of schemes. At every stage they are required to hold local inquiries for the purpose of giving interested parties the opportunity of being heard. Their authority extends to the creation of bodies who may exercise all or any of the powers of the authorised undertakers within the electricity district, and to whom the undertakings themselves may be transferred on terms settled by the Commissioners. On principle and on authority, it is in my opinion open to this Court to hold, and I consider that it should hold, that powers so far-reaching, affecting as they do individuals as well as property, are powers to be exercised judicially, and not ministerially or merely, to use the language of Chief Baron Pallas, as proceedings towards legislation. On these grounds, I consider that the appeal against the order of the Divisional Court discharging the rule nisi for a prohibition must be allowed with costs here and below, and the rule for prohibition in the terms of the rule nisi must be made absolute. The appeal against the order refusing to make the rule nisi for a certiorari absolute is dismissed without costs." End quote.